Transportation Committee for Wednesday, January 22nd, 2020 to order. Clerk, please call the roll.
Calling the roll, Ms. Baker.
Here.
Ms. Simon. Yes, here. Mr. Jones. Mr. Jones is absent. Mr. Miller.
Here.
Mr. Schrein. Mr. Schrein is absent. There is a quorum.
Thank you. May I have a motion to approve the minutes from September 17th?
I so move. Second.
Thank you. All in favor, say aye.
Aye.
None opposed, minutes are approved. All right, Madam Clerk, please read the first matter referred to committee, R 2020-0016.
Resolution number 2020-0016, approving and concurring with amendments made to the Northeast Ohio Area-Wide Coordinating Agency Code of Regulations.
Thank you. And Director Foley, I believe you're going to give some testimony.
Thank you, Madam Chair. Mike Foley, Department of Sustainability. This is a change to the NOACA bylaws. NOACA is the regional planning organization. It has, as you recall, 5 counties that are part of it: Cuyahoga, Medina, Lake, Lorraine, and what am I missing? Geauga, right? In order to make, when NOACA makes changes to the bylaws, the 5 county members have to ratify those changes. This change is basically fixing an error that happened about 10 years ago in how the board was composed. So there's kind of a formula to look at the census and then think about, where are people located at, and then allocate board members based on kind of population. When they did this 10 years ago, they created the formula, but then they actually made a math error that minimized, basically harmed Cuyahoga County. Basically, we kind of lost 2 board seats out of this if the formula would have done correctly. So this is to fix that error, basically increase the amount of board members to 46, keep the formula the same, and we think that at the end of the day, it'll benefit Cuyahoga County when the new census comes out.
Good. Well, I guess after 10 years, it's good they caught it. Any discussion? Yes.
How many total board members?
There's 44 now, plus 1 ex officio member, and then this will make it to 46 plus the ex officio.
How did this error get caught now?
I don't know. It got caught like 3 or 4 years ago. I think the city of Cleveland understood. Hey, wait a minute, what happened here? You're supposed to have another seat for the city of Cleveland. Specifically, kind of lost a seat.
Who determines this? I mean, how did this? Who's the individual or group of individuals that determine the allocation? So next time we can be obviously aware of paying attention to this.
Yeah, so this will fix it. So this will add 2 board members to it's based on kind of current population. This will add the 2 extra board members. And so no county is losing a board seat. That was one of the things that, like Geauga County especially, wanted to make sure that there's at least a minimum 3 board members for each county. So this fixes it in order to kind of increase the amount of board members, and which we think will accurately allocate board members to
Director
Cuyahoga
Foley,
County.
I know that we're fixing it, but I wanted to know who made this error. How does this error get made? Who determines the allocation? Who takes the math, does the math? That's the question.
So each county then makes their own determination on their own. So we get 24, right now we get 24 board seats, and the county decides who, between us and the city of Cleveland. And
Not who, how? Who determined how many, who made this error? Okay, let's put it that way. Who made
NOACA
the-
did 10 years ago, basically, when they...
In NOACA, who makes these decisions? Is it the
board
NOACA board?
The board makes these decisions.
So the board itself made an
the
error
error, right.
of math.
Correct. Mm-hmm.
There has to be an employee of NOACA that actually oversees this and does it. I mean, the board probably doesn't sit there and calculate math. The board is probably given the formula and approves it and discusses it. And I would like to know who at NOACA does this work. I'm sure it's somebody.
And it was before I was here, so I'm not sure.
Not the individual, the position.
Yeah. So NOACA has an executive director, Grace Colucci. I don't think she was there at this time. I think she came after the 2010 changes were made. And I forget who the board member, the president was at that time, or the executive was at that time. And I don't know who the staff was at that time either. But the board approved the changes back in 2010,
So
2011.
it's the executive and staff. That's what I figured. Yeah, this is not okay. I mean, we're struggling in Northeast Ohio. As up here as we need the representation. So I don't know, this is really disappointing, but I'm glad now we got it.
Yeah, so this fixes it, basically.
So the census that for 2020, which is different than the 2010, is there any population decrease that we could be in losing any of these seats?
My sense is it'll be roughly that we will get the two new board seats that.
Okay,
when
so
the
that might be
population goes-
something too, as to Councilwoman Simon's point, we need to watch that to make sure that the math is right, that we don't lose what we just gained that we didn't have 10 years ago.
Correct.
Maybe we can retroactively have a board member there to make up for what we lost, if that comes to be in population loss. But like you said, it's fixed now, and I'm glad that they're there. Any other questions?
Just a comment.
Go right ahead, Councilman Miller.
Just like to point out that the NOACA board passed a resolution submitting this proposed amendment to the 5 counties. And the original resolution gave the 5 counties until December 31st, 2019 to ratify it. It requires all 5 counties. And when a few delays occurred, they extended the deadline to January 31st, 2020, so that Geauga County and Cuyahoga County could hopefully get their ratifications completed. And so that would mean that we should hopefully recommend second reading suspension so that we can pass this on the 28th and ahead of the end of the month.
That's right.
I agree. I believe that's your request.
That's my request. Yeah, thank you, Councilman.
Any other questions or comments? All right. Yes.
I'll make the motion then to that effect, and also as the county's representative to NOACA, for the council, I would ask if my name could be added to the resolution. And I'd like to move resolution 2020-0016 to the full council with recommendation for second reading suspension.
Do I have a second on that? Thank you. Any other discussion? All right, all in favor, say aye.
Aye.
None opposed, motion passes.
Great,
Thank you
thanks.
for your testimony.
Yep.
All right, Madam Clerk, can you please read 2020-0017?
Ordinance number 2020-0002, amending sections 406.01 and 406.02 of the County Code to clarify contents of the whistleblower provisions.
All right, sorry, I had the wrong number. Okay, let's see, I think we're going to begin. Would Councilman Miller or Inspector General, did you have a preference?
I think I'll let the Inspector General go first.
Then we would like to hear from you.
Mark Griffin, Agency of Inspector General. Councilman Miller, you are too generous with time. I appreciate it. But I also want to say thank you to you for your hard work on this amendment. And I also want to thank Jim Boyle and Brendan Doyle from council staff who have really worked hard on this. This is a project that actually has been in the works for some time now, starting sometime before last summer, and then actually worked on by one of our case law school interns, Jeffrey Scott, to amend the whistleblower statute that we have in the county with several goals. First goal was to encourage more reports of wrongdoing or improvements or violations of code, and to encourage those reports by eliminating unnecessary hoops and also providing multiple avenues to report problems. And although I want to hear about every problem, some people may be more encouraged if they can report to different places, either their immediate supervisors or human resources, depending on what the issue is. And so we want to expand that opportunity to do that. So working with a council staff, there have been some major changes, and I'd like to highlight those major changes and then kind of walk through the wording of the legislation, if that is okay with you. Okay. The first thing we wanted to do was to actually change the sequence of the sections that are currently in the code, because as it stands now, the code is not particularly inviting because it starts with obligations of a whistleblower instead of protections for the whistleblower. So we wanted to flip those to make it clear that we want more information. Secondly, we wanted to expand it to make it clear that we're including within the protections for whistleblowers violations of county rules, not necessarily just state ordinances or other things. We're adding the Department of Human Resources as an avenue for whistleblower complaints, as are the person's specific supervisor or supervisory chain. We also eliminated the written requirement. We want people to not have to fill out a form or put something in writing. We want to make it easy to report wrongdoing. I think that's very, very important. We also emphasized protections against retaliation by putting that as mandatory training for supervisors so that everyone knows that whistleblowers are to be protected, not discriminated against. And then we also provided a 5-day window, so if a supervisor gets a complaint, they need to forward that on to my office. So with your permission, I'd like to kind of talk generally about the ordinance and the amendments that have been proposed. I don't know if everyone has a copy of it, because I'd like to
We
kind of...
should have it all in our packet, yes.
Do we have that? Great. And again, I want to thank council staff, Jim Boyle and Brendan Doyle in particular, for working and taking kind of our discussions and putting them into actual language. So section 406.01, the new one, first of all, reflects the reversal of order of the section. So we put whistleblower rights first and responsibilities second. But then in subsection A, we clarify several things. First of all, that we include county rules as well as state or federal ethics laws as well. But also we add within that subsection A that they may report to a supervisor within the employee's chain of command, Inspector General's office, which was there before, or the Department of Human Resources. So depending on where the whistleblower feels most comfortable, they can then start it through that channel. And you'll see later on that it has to come to my office, but it gives them more opportunities. Subsection B is really just a moving up from where it was before under responsibility. So we wanted to highlight in terms of sequence that retaliation is prohibited. So the B section simply moves that up, and it also changes the language slightly because previously it was files a whistleblower complaint, and because we've eliminated the writing requirement, it's now makes a whistleblower complaint. Section C also clarifies that these protections are in addition to the Ohio Revised Code, where it talked about a sole remedy is to file an appeal with the Personnel Board of Review. And what we're saying is, hey, in addition to that, you can also come to us to at least report the retaliation. So we thought that was another way of expanding and protecting whistleblowers and encouraging transparency in county government. New subsection D, again, reflects some of these other issues. So it adds different avenues for a supervisor within the employee's chain of command, the agency of Inspector General. So that gets in there as well. If you move down a little bit further into subsection D, you'll see we've added the words verbally. And actually, as we draft this and go forward, you'll see it says must be filed verbally. I would suggest that should probably be may be made instead of must be filed. So that may be some tweaking of language as we go through this process. Subsection E relates to the annual training requirement, where supervisors understand or will be trained on how to handle these situations and understand that they may not retaliate against any person who has made a whistleblower complaint. So that gets us to what had been the old subsection 1, which is now subsection 2. And we initially had a section there which put an obligation on employees to report within 5 days. And we tried to make it a little bit more consistent with encouraging and making it possible to do that. So, but we now have, we've moved down to a new subsection A, which continues to prevent or prohibit, rather, any false claims. So anyone who knows that they are making a false claim will be violating the ethics code. One of the things that we train about, though, is you just have to have a good faith belief. You can be wrong that something has occurred, but you can't knowingly make a false report. So that is consistent with the prior code, but again, we change it from the file a complaint to make a complaint. What had been subsection D, we've moved up to the top to actually make it more prominent. What's new subsection B is simply, it clarifies that it's a separate violation. One of the pieces that I would add as we tweak this is all complaints of retaliation, we need to put under this section. As it currently stands, retaliation for discriminatory conduct goes to HR. So my office doesn't want to be the super HR department. And so we just want to clarify in this piece that if it is a claim of retaliation based upon a report of discrimination on the basis of race, creed, color, sex, sexual orientation, disability, age, that will continue to go to HR, where they have the expertise to deal with those pieces. That's the way it currently works. And we just wanted to continue that, so we would ask that the words under the retaliation under this section be added in there.
Where are you at on that piece?
Yeah, I'm sorry. So
is
it's the new subsection B,
Subsection B.
which comes under the old subsection D.
Got it.
Councilwoman Simon, are you following? Are you? My apologies.
I'm looking at B on page 9 of 11.
I'm sorry, and it should be page 10 of 11.
10 of 11.
Thank you.
So old B is not crossed out.
Yeah, I'm sorry. So I was referring to page 10 of 11.
Okay.
And if you go down to, and again, the way the red line worked, it's a little confusing.
Okay, I'm looking at, okay, so this is, I got it. 406.2.
Correct. It would be exactly where it says any act of retaliation, and we want to insert the words under this section.
Okay, so that's where you're at. All right.
And thank you for asking me to clarify. I don't want to.
Yeah, just trying to follow. Yeah.
Sure.
I have a question. Can I
Okay.
ask
Did you
now?
have one more to finish, or are you?
Just the last subsection,
can
which
you
is the
finish
new
just the last,
subsection
and then we
C.
can open for questions. Go right ahead. Why don't you finish, and then we can.
And that simply has a requirement that if a supervisor receives a whistleblower complaint, because we have these multiple avenues, they still need to report it. And we have within 5 days to the Agency of Inspector General.
Okay.
Okay.
Yes, go right ahead.
I think I understand why you want to have HR be one of the options to which people can complain. But it might be, I don't know if everybody's going to read the manual that well. I mean, if they can call the IG for whatever, right? I mean, if for some reason it's a discrimination, type thing, they can call whoever, right?
Yes. So yes, they can call anyone. And so we do get, probably every month we get a claim of discrimination, which we then refer over to HR.
Yeah, I think this is aspirational. I mean, people are going to call who they're going to call, and I mean, they're not going to be precluded. So that's you're just trying to streamline it as best you can.
Well, let me also say this, which is we have had cases in which people have made these reports to their supervisors, but not to us. And then under the code, they're not protected under the whistleblower statute. And so we want to make sure that they do get that whistleblower protection. And I don't want to talk about specific cases, but there have been some in the news recently where there have been whistleblower complaints to people within the executive branch, but not to us.
So they'll be protected if they call either HR or IG?
Yes.
Right.
Yes.
Okay, and you think this will help at least clarify that to
I
as
do.
best we can? Okay.
Obviously we have to follow the law, and we try to be expansive in our ability to protect whistleblowers, but the law is still the law. And so we don't want to be in a position of saying, hey, you don't have a whistleblower complaint because you failed to check the right box. You went to, I'm going to make this up, Department Director X with your report instead of to us. That seems to be not consistent with our desire to encourage reporting and to protect whistleblowers.
Okay, second, we spent a lot of time on this original ordinance with, talking about the written requirement. I don't think I've ever been totally comfortable with that. It just takes away some anonymity but I think the reason was to try to cut down on, fraudulent or, those kind of complaints. So it's a balance. I think it's okay not to be in writing, but I think what the issue was is we didn't want a lot of false complaints being alleged.
And let me respond to that also with respect to my practice before I came here in representing plaintiffs. And we did not have, at least in my experience in private practice, of people disputing that a complaint had been made verbally. And so we didn't have experiences of false complaints. Now, there were situations where employees, in fact, made complaints that weren't in good faith because they were trying to protect their jobs. But that doesn't have to do with a verbal or a written requirement. And so my experience has been that you don't have a lot of people falsely claiming to have made a verbal report.
So what happened with, one more, with the 5-day, I thought, I was never really comfortable with the 5 days either, but what happens now? What's the limit? I didn't see it.
So we changed it.
I know you changed it.
There
To
had
what?
been a requirement that anytime a employee knew about a violation, they were required under these rules to report within 5 days. And frankly, it wasn't really clear whether it meant that they were deprived of whistleblower protection if they didn't do it within 5 days or not. So the ordinance wasn't clear. But the other piece is sometimes it takes employees a while to think about what they should do or to even see a violation. You see something that happens, and it may take you a while to say, well, wait a minute, that's wrong. And that realization can take more than 5 days. So we thought that was creating a requirement that was unnecessary and could discourage people from coming forward. So let's say a whistleblower comes forward on the 6th day, and they say, hey, I want to report this, but under the old section, they might be in violation of the rules because they waited an extra 24 hours. And what we want is more information, more reports, so that we can try to fix problems.
So there's no new deadline.
The deadline has changed now. So the deadline is now on the supervisor to report what they have
To the IG.
to the IG. And whether it's 5 days, one of the issues that I would put to this committee and to council is whether that 5 days for supervisors is too short, too long, appropriate. I don't really feel strongly one way or the other. I mean, I don't want it to be, a year, but I don't know whether it should be 5 days or 7 days or 5 working days or 30 days.
I understand. And should we leave it wide open for complainant to have a year or two to submit a complaint? I mean, that's pretty much what we've done. If we take out any time frame for somebody who actually is the whistleblower, is that something we want to leave wide open?
I would advocate yes.
Okay.
Under our state code, there's no date timeline. And so, I don't know that we need to have one under our
No
county
statute of
code.
limitations on this.
Right, exactly.
Okay.
And let me give you an example. A famous case of wage disparity by a woman who was underpaid for years and years and years. And I think as a lawyer, you probably know about this. She was underpaid for 30 years. And the Supreme Court, when it finally came, said, oh, no, you waited too long because your underpayment occurred decades ago. We at least want that information to come forward. And, if we can fix the problem, I think we should. Let me also toss out a couple more issues that have been raised, I think, in discussions with council and council staff. One is that this does not have a definition of what a whistleblower is. And we don't see that in other legislation either, but there's been some discussion, I know, with staff that might be appropriate. Another piece that I think is very important is anonymity or confidentiality. And I just want to flag this as an issue, which is, we are subject to public records laws. And so once our reports are closed, they become public records. And that creates an issue or a way of discouraging some people from coming forward to us at times. But that is the law that we follow. And I don't know whether we as a county can change what the Ohio General Assembly has to say about public records law, but that is an ongoing factor about maintaining confidentiality of whistleblowers.
Okay, interesting. Councilman Miller, did you want to add, given your knowledge of this?
I'd like to, first of all, thank the Inspector General for his collaboration and working with me on this. The genesis of this legislation was that in the course of dealing with a couple separate events over the last year, the Inspector General made comments that he didn't think the current whistleblower legislation was strong enough and was the best it could be. So after hearing this a couple times, I got together with Mark and said, well, what would it take to make it right? And so we agreed to work on it together, which we did over the course of a number of months, and so that's what generated this legislation. I do believe that it would be most desirable to create an atmosphere where people feel confident and comfortable in coming forward and feel that they're going to be protected and that there's also protections to ensure that the whistleblower process is not used wrongfully and that complaints are put forward in good faith. And so we're hoping to strike that balance. And I would also say that that this legislation, although a good amount of work has been done on it, it's clearly of a preliminary nature. It's going to require more discussion. Executive Budish has asked to meet with me about this legislation, which I'm looking forward to doing, and we're going to have to give further thought to some of these details. So I think it's going to take some time, and my hope for today is that the topic could be introduced and that some of the relevant issues could be put on the table, and I think we've been going about that task. So that's where I think we are.
Thank you, Councilman. Couple questions, because I haven't been involved in this, so it's new to me. The verbal piece of this seems to be perhaps problematic. Would a verbal complaint or whistleblower concern be like a tip? Would it be more like, I'm calling in, I'm giving you a tip that I think something's going on in this department, and I need you to take a look at it? No name, no more than that, but it's just like a hotline tip. That to me seems more of what a verbal complaint would be. How is that? Yet if they put it in writing, then you have something that's documented that perhaps can be followed through with whoever did document it. And is that document that they have now as a whistleblower, does that need to have a name on it, or can that be anonymous?
We have anonymous hotlines, so they can. The reality, though, is that people don't necessarily know where it is, and
Okay.
so they'll call us or they'll send us emails, or sometimes they'll just come by our office. But I think you're right that it is like a tip, and I think the key part is that they shouldn't be retaliated for giving those tips.
Right.
And the hope is that no one ever finds out who provided an anonymous tip.
Right.
If they were to claim retaliation, they would have to prove that their supervisor or whoever took the adverse action was aware of this. And it doesn't come out of my office unless we're required to produce it.
Right.
So there's still an obligation to prove a case of retaliation at that point.
But if someone were to anonymously call your office, you don't know who they are, maybe they're calling from home, so there's no trace of a call, and just say, I think that you need to investigate, and they give you the details, and then that's it. There's no more follow-up from them. They don't check back in. They don't give you your name. If you don't do it, you don't do it. How is that? Is that something that you would take seriously if an employee did that?
Absolutely.
Okay.
Now, the level of seriousness would depend upon the detail that we get and whether our preliminary inquiries show that there's anything, if there's any there.
Okay.
And, over the course of the last year and a half, I'm thinking of one person in particular who calls in as John Doe, and he has a variety of issues that he has pointed out to us to follow up on. And he doesn't want to give us his name, so that's fine. He calls from a different phone. So yes, absolutely. We look at anonymous tips,
Okay.
but then we judge them based upon, does this make sense? When we start looking at it, is there there?
Right, then the responsibility shifts to you.
Yes.
Yes, and to me, that seems like, I don't know why that can't continue. I mean, there's, I'd have to give that some thought. Also, there's a, yes, go ahead. You had something to say, something on that? Sure.
Just a comment that if I were making an anonymous complaint, I would also do two things. The first thing I would do is that I would make a personal journal at the same time that I was making the complaint, and my own personal record of who I spoke to and what I said. And the second thing that I would do is that I would talk to one or two other people that I trust in confidence, and let them know that I made the complaint, so that if somewhere down the line somebody suspected that I made this complaint and retaliated against me because of this, and I sought whistleblower protection, that I would have some evidence to show that even though I didn't put it in writing, that I was actually the person that made that complaint at that time. So that's what I would do, and I think if we do allow for an anonymous complaint or a verbal complaint to be whistleblower protected. That's what we're proposing here. But the person who makes that complaint, it would behoove them to be able to show that they actually made the complaint.
They may not be as diligent, of recording and,
Let me add another piece, which I think may address the issue of false claims, which is whistleblowers are protected from an adverse employment action because they filed a complaint. It doesn't protect them for not doing their jobs or for malfeasance in office. So, they could be fired for other reasons, but they can't be fired or demoted or have their pay cut because they filed a whistleblower complaint. And I wanted to mention this before, but I do want to, I think, emphasize what Councilman Miller said, which is I view this as the start of a conversation. And, these are ideas that have been incorporated, but I think that as we work together to figure out what's best for the county, I think everything is open for discussion.
yeah. I know I've talked to you in the past about complaints that may come within a department, and sometimes you'll send that employee back to that department and say, you need to work this out with your supervisor. So that judgment call is on your department. Is that something that you would continue to do if this started with since we're changing it to the supervisor?
Yes. Yeah, we would continue to do that. Or we continue to work with HR, because oftentimes we get complaints that are kind of HR related. So we try to refer those. And by the way, I want to thank this committee and council for the change requiring responses, because one of the things that's happened is that when we refer these HR-related matters to HR, now we have the ability to follow up, and so we're continuing to do that, and that makes a difference.
Yes.
It has made a difference.
Great. I'm very glad to hear that. I think that this probably needs more discussion, absolutely. I think the most powerful part of this legislation is the 5-day lifting of that requirement. I think 5 days probably is not, it's not of any fault to the whistleblower that it's the 6th day or the 7th day. So that, I think, is worth taking a hard look at what this presents. Other parts of this, you may have other members perhaps giving some concern over the details. But I think overall, it's good that we're coming back and we are defining what a whistleblower is and taking a look at the verbal tips. 5-day limit, I think, is something that we need to consider. I think that, I would think that, from your experience, I'm not sure an employee would go to their director if it's in their department that the issue is stemming from. So, there could be instances where they would, but I think that they would probably like to go to a third objective party, which is what exists now, going directly to you so that they don't have any underlying retaliation. It may not be, but there's other ways to retaliate that isn't documented. So I question whether, but in your experience, do you find that they try to go to their supervisor first?
And sometimes it's not their immediate supervisor. So sometimes they will go to the department head,
Okay.
and then that can create an issue. But the thought here is to give employees more flexibility and more options. So, I think and I hope that the majority of employees may feel comfortable coming to our office, but we want to give them options.
Madam Chair.
Yes.
You're going to have situations where an employee has a very good relationship with their immediate supervisor, but not necessarily with the higher ups in their department, and so they may feel comfortable going to their immediate supervisor and saying, I think there's a problem and this is what it is, So
Okay.
I think it's good that to have that as an option. I think other options would probably be used more frequently, but there would be times when that would be what a person feels most comfortable with.
Okay, interesting.
The Ohio Revised Code phrases it slightly differently, which is they can go to someone who has the ability to solve the problem, and so that may be a different way of looking at it, or a different way to skin the cat.
If there is no limit to time, how does it work when an employee leaves his employment here and then maybe 6 months down the road say, hey, I saw some things happening in my department? Are they, because they were a former employee, how does that work with them?
Well, so if they are no longer employed by the county, they can't be retaliated against because they're not here. They can't be fired, demoted, that sort of thing.
Yeah.
But we absolutely will take tips from anyone who leaves. And one of the issues that we've had, and again, I want to thank council for this, because we've had the ability to now have subpoena power. One of our issues has been with former employees. How do we talk to them? Because some people want to talk to us, and that's great.
Right.
But for those who don't, the subpoena power has been very important.
In looking at your report that was dated June 30th, 2019, you have a section on whistleblower in the statistics. And it's interesting that you have 38% comes from the public
Yes.
and 37% are current county employees. So it's almost, the others are smaller. 14% is your initiation. But it's interesting to see where these source of complaints come from and how this new legislation then would affect that 37% that come from our current employee.
Yes.
Yeah.
Yes.
Okay.
May I ask a question?
Yes, go right ahead.
My question is whether the whistleblower legislation, either as it currently exists or as it could be revised, would it provide protections to a non-employee?
I do not
Take-
believe, I'm sorry.
Take the following scenario. A person, let's even presume they call your office, they file a written complaint, they know about something that's not right, and they ask you to do something about it. And shortly thereafter, the person applies for employment with the county, and the person doing the hiring knows about the whistleblower complaint and throws the application in the trash can. Is there any protection for something like that?
I don't believe so.
Only employees.
Yes.
Okay.
All right. Well, I think there's more discussion on this, and we will probably reschedule another meeting.
Right.
And I thank you for your testimony. Very interesting, and I think there's a few key things in here that absolutely need changing, and others we may have more discussion on what we need to do to feel comfortable in putting this forward.
Councilwoman, thank you very much for the opportunity to come talk today.
If there's
Appreciate
no
it.
other discussion, all right, we will adjourn. Thank you very much.
Thank you.